everybody. This is Arkady Frekhtman, a New York City personal injury trial attorney, and welcome to Last Week Tonight, where we answer your questions and we talk about your comments. It's all about you, the viewer, in this episode. So let's get to it. We're about 3 weeks away, and I know some of these questions we've answered live, but I wanted to do a few recordings as well, just so we could catch up and make sure everyone's questions and comments are being addressed. So here's a question from Ricky Harris. This is about 3 weeks ago, and he says, "Thank you for the wonderful information, Mr. Attorney Frekhtman. I'm about ready to check in the doctors again due to pain and extreme headaches. Will something like this slow down the process if I go back in to get checked out? Thinking I may need pain management medication for the pains in my shoulder and arm. No, I don't think it really should slow you down. As long as you've already had a diagnosis and you've already had some treatment like a surgery, your lawyers will know what your injury is. The fact that you're going back, due to symptoms like pain and headaches, you're just trying to feel better, which is natural. So you're going back to the doctor, you're just getting checked out, and that could be just a supplement, right? Or an addendum to your medical records. But it's fine. I wouldn't hold up, not wait to file the lawsuit. Go ahead and have the lawyers file the lawsuit, move the lawsuit, and then you just give them the authorization for, this doctor. If it's a new doctor, if it's the same doctor, you just give them an authorization for an updated narrative or an updated progress note that the doctor fills out. So it's totally fine. It shouldn't slow you down. Some people, in fact, they get really hurt, so they have to treat, and then they're going to be treating for the rest of their life. So they're not going to wait, forever. It's fine to file a lawsuit, and then you just supplement it as you go. At least that's the way it is in New York. I don't know if other states are a little different, but in New York, you definitely want to file it as soon as possible, as soon as you know what the injury is. And here's a question. Can you do a video on a lumbar laminectomy surgery that includes 3 epidural steroid injections, a radiofrequency ablation, and physical therapy? I was diagnosed with a disc protrusion and radicular symptoms. Rear end accident, stopped at a red light, and I live in Pennsylvania. The company accepted liability. Okay, so a lumbar laminectomy surgery. Yeah, that could be serious. I mean, I don't know what city in Pennsylvania or what the details are, but the lumbar laminectomy surgery itself, yeah, I could do a video just explaining that surgery, but it's a spinal surgery, so that's pretty serious. That could be worth anywhere from, I would say, mid 6 figures, like 500,000 or even up to $1 million. And the fact that you had 3 epidurals, just 3 epidurals, we've settled cases for over 100,000, even 150. Radiofrequency ablation is serious, physical therapy. So yeah, disc protrusion with radiating pain, that's known as radiculopathy. So yeah, lumbar laminectomy. So I'll do a video about that. I'll do a little research about that. Maybe I could show some of the slides of exactly how the surgeon performs the surgery and explain it. But that is a serious back surgery, so that should be a big case. Okay, and then let's see what other questions we have here. Dragomira says, glad to see, hope all is well. The scale behind you is constantly moving throughout the video by itself. I think your house is haunted. Oh, maybe she means this scale? I don't know. Maybe the air conditioner is making it move. I don't know. Shouldn't be moving by itself, but who knows? I don't think it's haunted. Hope not. I'm here. And then Roberts Zante says, Ella is a great cat. It's amazing that she actually watches movies on the TV. I don't know what that is. A great cat. I don't know how that's related to our videos. Maybe his cat watches our channel. That's pretty cool. Cats could learn about injuries too. The cat lawyer. There was that one funny thing where the lawyer was a cat or something in the Zoom. I don't know if you guys saw that. It was really funny. He had a face of a cat, and he didn't know how to change the filter, and he got a little bit in trouble with the judge. That was pretty funny. And then Come Along with Uncle Joe says, can you make more tort videos? And I guess by tort, he just means personal injury. When you go to law school, you study tort law. So torts are just like personal injury, basically. All types of torts, all types of negligence. So it could be personal injury. It could also be other types of damage. Like, for example, if things get damaged, that could also be a tort. Like if a truck, I don't know, spills something negligently, some kind of oil, and the oil destroys maybe your like you have coats stored there and it destroys your coats. That could be a tort too. You sue them in tort, but it's not a personal injury. It's just a destruction of property. Okay. And then Reginald Williams says, is a post-concussion syndrome the same as a traumatic brain injury, coup contra coup axonal injury? My neurologist diagnosis says post-concussion, but diffuse tensor imaging says coup contra coup and axonal. Which is the diagnosis? So basically, coup contra coup just means that the head hits a stationary object. So if your head hits, for example, like the windshield in your car, right? Could be a coup contra coup. Diffuse axonal just means that the connective nerve fibers in the brain were cut or sheared. So, for example, you have axons, right? And there's like 84, or maybe, I forget, is it 84 or 86, but either 84 or 86 billion neurons in the brain. And the way that neurons talk to each other is through the axons, right? They have like axon terminals, and then it's electrical activity. And that's how your thoughts will travel through. So if you have these connective nerve fibers getting sheared or getting cut, that's known as diffuse axonal. That could be a very serious injury. It's also known as DAI, diffuse axonal injury. And post-concussion is just more of a general diagnosis of a traumatic brain injury symptoms that last longer than expected. Because say you get into a concussion, you expect to have some kind of symptoms, maybe for a week, then you want to get better. And most people do get better, but sometimes they don't get better. And then you have these post-concussion syndrome, even 6 months later, a year later, well, then they may be permanent. They may be there forever. So that's more of a general term. So it sounds from your comment that the DAI, the diffuse axonal injury, is the most significant diagnosis. But I would definitely get that worked up, maybe through well, you've already had it, says the DTI. So the DTI should be one of the ways to work that up. Maybe also a PET scan or a color imaging. But that's very good. That's very good to be able to prove that, because sometimes an MRI will not show. The MRI is not going to be that intense that it could show all of the neurons, because like I said, there's like 80 billion of them. They're not going to show every neuron. They're not going to show shearing of so the only way to really show it is through the diffuse tensor imaging, the DTI, or some other radiological scans, as well as an examination by the neurologist and a whole brain injury workup. And then he says, I wish you were my attorney. 5 months with my attorney, so I'm not switching. He's a trial attorney, top 100 on the trial attorney list. I just love your thorough explanation and the way you make me feel when answering my questions. I don't feel like I would be rushed with you. I'm sure the associate attorney I'm working with at the firm is overworked, so she doesn't have the time to explain clearly. She loves to say, I'm not a medical doctor. I think this is her way not to go down the medical question rabbit hole. It's so annoying, but I can tell she's straight pit bull by the way she speaks, so I will wait it out. Yeah, good luck to you. I don't know what state he's in. I forget. Maybe he texted me before. But yeah, feel free to text me. Even if he's not, it's not about whether he needs to get a new lawyer or not. I'm happy to just do a consultation. Maybe I could give them some kind of insight. So yeah, feel free to text me if you have time, if you have any other questions. But thank you for your kind words. Yeah, I'm happy to provide any kind of guidance to the extent I can. Absolutely. Let's see. What other questions do we have here? Here's somebody, Go Yo. He's saying that this is about the Florida video. They had some tort reform in Florida, and I think he's saying that letters of protection can be used to inflate claims. Oh, because billing under letters of protection are generally 3 to 5 times higher than any other form of medical payment. So, I don't know. I'm not sure. I don't work in Florida, but basically in New York, whether the amount is a lien or a letter of protection, or it's paid by, let's say, workers' comp or no fault, it's all considered medical insurance. So the medical providers can't really abuse the system, because then they give, basically they're giving credence to tort reform, right? If they're abusing the system, like for example, let's say you have a no fault case, and then you say, okay, I did a physical therapy session, that's $100 and you get paid by no fault, and then, you know, but if you have like a letter of protection or a lien, you say, okay, I did that physical therapy, the same thing, but I'm not going to take $100, I want $1,000. Well, that's going to be like, wait a minute, why? It doesn't make any sense. So I don't think you could really do that. That would be like very, very tricky and unfair. And then you're being the one as a lawyer, you know, or as a doctor representing an injury patient, you would lose credibility. So that would be really bad. So hopefully no one's going to do that, because that would hurt everybody. Okay, let's see what other questions we have. How long does a summary judgment decision take? Yeah, usually it takes about, 60, 90 days. It depends on the judge. Usually a few months. I've never really seen it be more than a few months, but sometimes judges just kind of let it sit and, let it linger a bit. I don't know why. I guess they're busy, or they don't have time to get to all the motions. They might have a lot of motions. Here's a question. Vic Centeno says, if there are 3 defendants and 1 lawyer, is the judgment times 3? For example, 1 million each defendant pays 1 million. 3 defendants and 1 lawyer. Oh, I see what you're saying. So if the judgment is 1 million, each defendant pays 1 million. No, I mean, that would be if the judgment is 3 million, then, each defendant would pay. The way it works is, it's whatever the judgment is. And the way it's paid usually is based on the liability percentage. So first they might say, 3 defendants, each of you are liable 33%, then each of you will pay equally. But if they say 1 defendant is 10%, and then 1 defendant is like 50%, and 1 defendant is like, whatever. So they'll pay in proportion. So let's say it's $1 million judgment, but you're only 10% liable, so you only pay 100,000. You only pay your percentage. But also, you don't get more just because you have more defendants. It's whatever the total judgment is. You could have 10 defendants, but if the total judgment is only 10,000, well, then you just get 10,000. It's whatever it is. So yeah, it doesn't increase by the number of defendants. Okay. Shannon says, hi, Mr. Frekhtman. I had a question about depositions. I did mine 2 months ago, and the lawyer for the defense is stalling and not setting dates for his client. Is there a motion we can file to move things along? Yeah, I mean, usually you want to file a motion to compel or a motion to strike the defendant's answer. That's what it's called in New York. But I think pretty much everywhere it's known as a motion to compel, because you have that scheduling order from the court. So you just want to make sure that they follow the schedule. And so it's to compel, it's to enforce the court order, just get it moving, And if they don't do it, then the judge could strike their answer, or the judge could impose some kind of penalty on them. Let's see what other questions we have. Lawyer reacts to $1 million slip and fall trial closing. And then Reginald says, he felt uncomfortable asking for money. You can tell in his voice, but he rebounded when he itemized the numbers. He got better. I wonder what the store offered. I think the defense was thinking a shoulder injury wouldn't get to 7 figures. They probably wanted to give 5 times medical bills. I guess they learned a lesson. Offer more. Yeah, I don't know what they offered, because I just saw the trial. They had part of the trial on the Courtroom View Network, CBN. So I think I watched that part of the trial and I commented on it. But yeah, maybe in the beginning he was a little bit like, some lawyers have that issue. They're afraid of asking for money because, you don't want to ask for too much. Like you go up there and you say, hey, this case is worth $10 million. And then the jurors are like, $10 million, what are you talking about? And then you feel like, oh, so you have to really own it. You have to really believe in it yourself, and you have to deliver it with conviction. And I was watching another trial earlier this month, and the lawyer went up there and he did it really well. He said this case is worth from $20 to $40 million. And it wasn't that serious of a case. I mean, this is a more serious case, I think, the one where it was just a few $1 million, the one in this video that Reginald was talking about. This case was a car crash case in Georgia I mean, there were some serious injuries. There was some also radio frequency ablation, injections, a need for fusion, but there was not even a fusion. But he said, look, this is worth $20 to $40 million because it's a young guy. If it's $500,000 a year for like whatever it was, like 40 years, it's going to be like 20 million. And so he delivered it with a lot of conviction and a lot of confidence. And then basically the jury came back with less. They came back with, I mean, it was a 7-figure result, but I think that one might be up on appeal because one of the jurors lied. One of the jurors ended up being like an insurance adjuster. It was like a crazy story. So I'm not sure if I heard about that. I have to read the article to see if that's what happened. But he's done that before. The same lawyer, I've seen him other cases where he asked for like 60 million for a wrongful death, and then he would get like 10 million. But, you know, as long as you could deliver it in a way that doesn't sound greedy, that doesn't sound preposterous, and as long as you believe in your number, that's the main thing. That you believe in your number as the lawyer, and you explain to them like why you arrived at that number, like more like I don't know, some people say a rational basis or some kind of, it has to be some kind of rational or logical, basis. Some people talk about, just common sense. What is this worth? So, some states you could do that. In New York, you can't talk about what it would be per year. So for example, if I have a client who's going to live 40 years and I say, okay, we'll give him $500,000 a year for 40 years. And what does that add up to, right? So every 2 years, it would be $1 million. So over 40 years, that's $20 million. And it's fair because this is a life-changing forever injury. And some people make more than $500,000 just doing a job. And this is not a job anybody would ever sign up for. This is just completely changed every aspect of the individual's life. But you can't do that in New York. You can't do like time and base it on time. Like, I want like $1 every second or whatever. It's just not allowed. You'll get reversed. But there are other ways to do it. You could still talk about time. You could still talk about the passage of time, the fact that they feel pain every second, every hour, every day, but you can't ask for an amount per like year, per month, per week, per second, per minute, whatever. You can't do that. But you could still, explain it. You could still say, for the past, from the date of incident until now, we think a fair amount is 3 million. For the future, we think a fair amount is 10 million, whatever it is. And just as long as, and then explain, and then the total is 13 million, and explain like why. And also sometimes you have to explain lost wages, or you have to explain medical bills. Some patients, they have serious injuries. They might have like a life care plan, or they might have a narrative report from a doctor, and it'll talk about future medical expenses, like future surgery, future physical therapy, future prescriptions. And you have to talk about that. But a good way to explain that is to say, look, this isn't not money that's going to my client, right? This is not money that's going to the plaintiff. This is money that's going to other people to give him care, like pharmacies for giving him pain medication, or doctors for giving him radio frequency ablation injections, or giving him surgeries, or giving him physical therapy visits. So this is just money he's going to need in order to get his medical care. And that amount could be high. That amount could be a few million. So then you have your pain and suffering. You have that, which is your medical expenses, the future. You could have lost wages, and then it all adds up. And then you have your loss of enjoyment of life. So yeah, absolutely. It could definitely be a big amount. Definitely be a really big amount. And then Bit by a Turtle says, I think you need a slogan, Arkady. Then you should slap that bad boy on some merchandise. I would wear a hat with some legal jargon on it, but I don't think percutaneous discectomy has the right ring to it. Oh, that's funny. Yeah, absolutely. I mean, maybe a slogan. Maybe you guys could help me come up with one. I think I had a few slogans before when we did our advertising. We talked about things like serious lawyers for serious injuries. What would we think of a slogan? Definitely something to the effect of our mission, right? Our mission is helping serious injury victims and their families. So our mission is like providing justice to everyone. So maybe something I have to come up with a slogan. Yeah, it's a good idea. We have to do like maybe some merchandise. We can make some t-shirts or some hats. I think we have some kind of store that was just like automatically created, but I don't know if it's, I'll have to go in there, maybe have somebody fix some of that stuff, make it a little nicer, some design, some some slogans, we could do that. Absolutely. It's a good idea. Okay, let's do maybe one more question and then we'll call it for today. We're almost at the 20-minute mark. Here's a question. What if they recommend surgery for a torn labrum and a torn tendon, but you can't have it because of heart problems? Can you go ahead and settle? And how bad will that hurt your claim? I mean, it shouldn't really hurt your claim because remember, what they're going to argue is that if the doctor says you need surgery, but then you don't have it, but you can have it, that you fail to what's known as fail to mitigate your damages, right? Because surgery would get rid of all your pain and suffering. You can have it, just go ahead and have it, but then you choose not to, well, then you didn't lower your damages. So it's not our fault that we, crashed into you. It's your fault because the doctor said, hey, you could fix all this with a procedure, but you chose not to have it. But here you have the opposite. Here, you're saying that the doctor says you need surgery, you want to do the surgery, but then the doctor's also saying, well, medically you can't because you have a heart issue. So what I would do is I would just serve that report saying that you need the surgery on the defendants and explain, look, I can't have it because I have a heart issue. I could die, right? So I can't have the surgery medically. So it's not like I'm failing to mitigate. It's just I can't do it. So then give me a fair amount for what the surgery is worth, even though, because I do need it. So, and then it should still be a substantial amount. Like we had a case, I believe it was a $100,000 policy, and it was an older man. He was like in his 80s, and he wasn't going to do a knee surgery, and they offered him like $10,000. But then we had a report from the orthopedic surgeon saying he needs a knee surgery, and I explained it to the adjuster. I said, look, he's not going to have it. He's 80 years old. He's not going to have a knee surgery. He doesn't want to have any surgery. And then she said, okay, well, but the fact that he has medical necessity for it, right? The doctor thinks he needs it. And then she went up and she settled it for like almost $80,000. So it still could be a substantial amount. It might be a little less than if you actually had it, but it is what it is basically. A lot of these cases are about that, like pre-existing conditions. You come in with whatever you had before, but you can't recover for what you had before, but you can recover to the extent that whatever you had before was made worse. The same thing with this. You can't have the surgery because of a heart condition. Well, then you're not going to have the surgery. But the fact that you need it, the fact that that this is what it is for you, this is what your medical condition is, and you have to live with the pain because the surgery might have, remedied the condition. But now you have to live with the pain, and you can't fix the condition because you have this heart issue, right? So then you're left in this almost like forever pain, forever living with this torn labrum, torn tendons, and not being able to get it fixed and going back to a pain-free life because of this heart issue. But it's not your fault. That's just your medical history. That's just who you are. So they have to pay for that. So I think that it depends on how it's framed and depend on how it's explained. Okay, I hope this has been helpful. Let us know what questions you have. We are here for you. Please like and subscribe to our channel, and have a great day, everyone. Okay, bye-bye.